Hello everyone, I'm Abasud and today's topic in cloud compliance is legal issues, contracts and electronic discovery. So this is what I am taking detail from the CSA. So let's discuss about this topic. This topic highlights some of the legal issue raised by the moving data to the cloud, contracting with the cloud service providers and electronic discovery request in litigation. Many company prohibits or restrict the transfer of information out of their borders. In most cases, the transfer is permitted if the country to which the transfer offer an adequate level of protection of personal information and privacy rights of effective individual. The purpose of this adequacy requirement is to ensure the individual whose data is transferring across border will remain as protected as they were while policies afforded to them before the transfer of data. Alternatively, the data importer and exporter may need to sign a contract ensuring the maintenance of privacy rights for data subjects. Depending on the country, the requirements for ensuring this adequate protection may be complex. In some cases, it may be necessary to obtain prior permission of local data protection commissioner before transferring the data in or out of the countries. So let's look into what are the things which we need to take into consideration. The first is contracts and provider selection. Even if a specific activity is not regulated, cloud customer may have a contractual obligations to protect the personal information of their own clients, contacts, or employees to ensure data is not used for secondary purpose and is not disclosed to or shared with third parties. The obligations may stem, for example, from the terms and condition and privacy statement that a company posts on its website or from contractors that the company has excluded with third party. So let's look into it. What are the different things which we need to consider inside that? The first is the internal due diligence. Companies are the custodian of data entrusted to them. Numerous laws, regulation, contracts prohibit it, restrict, limit the disclosure and transfer of data to the third party. For example, we can look into the GDPR, we can look into HIPAA, that is Health Information Protection Act, which is applicable to US. So HIPAA under HIPAA, we cannot transfer the data to third party or business associate without imposing specific obligation on that associates. In addition, if data originates abroad, it is likely that there is a significant obstacle to its transfer cross borders into a country that does not provide adequate protection to privacy right and personal data. Before entering into the cloud computing arrangement, both the cloud service vendor and cloud customer should evaluate respective practices, need, and restriction to identify relevant legal barrier and compliance requirement. For example, a cloud customer should determine whether its business model allow for the use of cloud computing services and under which condition. The nature of its business might be such that it restrict by law from the control of company data. A cloud vendor may find it prudent to evaluate in advance the cost of doing business in certain markets that might be subject to legal issues. So, the nature of his business might be restricted by the law from leviation control of country data. Second is monitoring, testing, and updating. The cloud environment is not static, it evolves, and involved parties must adapt. Periodic monitoring, testing, and evaluation of cloud services are recommended in order to ins- ensure required privacy and security measurement measures are followed. Without periodic testing of cloud services, cloud efficiency may not be compromised in an undetected fashion. Next is external due diligence. The cloud customer will want to evaluate at least the applicable service level, end user and legal agreement, privacy policies, security disclosures, and proof of compliance with applicable legal requirements to ensure the conditions stated by the cloud providers are suitable for the customer's organization depend on the expected depth and intensity of the due diligence issue to be investigated may include the following. Will the service be re- reliable and easy to use? How will the service be used to process data? How will the service operate and be provided? Will data be collocated with other customers data? How will data be protected from intrusion and disasters? How will the price evolve over time? Will the cloud vendor meet the company's computing and access needs? Will the cloud vendor remain in business for next few years? And what is its financial profile? So next is contract negotiation. Cloud contracts are intended to be accurately describe the understanding of all the parties. Numerous precautions and measures can be taken by the parties to reduce exposure to legal, commercial, and reputational risk in connection with the cloud service. Next is reliance on third party audit and registration. In cloud computing, third party audits and registration are frequently used to assess compliance with aspect of the cloud provider infrastructure, allowing a customer to build their own compliance services on top of cloud platform. It is critical for a provider to publish and a customer to evaluate the scope of assessment and which feature and services are included in the assessment. So this is what we are having from the legal issues and contracts. So now we will be looking into the electronic discovery. So electronic discovery is a process by which opposing party obtain private uh, documents for use in litigation, cover a wide range of potential document. In particular, discovery need not to be limited to a document known at a outset to be admissible as evident in court. Instead, discovery will apply to all documents reasonably calculated to lead to admissible evidences. So what it in the discovery document, one is possession, custody and control. In most judicial in US, a party obligation to produce relevant information is limited to document and data within its possession, custody or control. Hosting relevant data by third parties such as cloud provider generally does not obviate a parties' obligations to produce information. However, not all the data hosted by the cloud provider may be in control of client, maintained by the cloud provider to obtain its environment, distinguishing the data that is and is not available to client may be in interest of both the client and provider at the outset of a relationship. Next is relevant cloud application and environment. On occasion, an actual cloud application or an environment could itself be relevant to resolving a dispute. In these circumstances, the application and environment will likely be outside the control of the client and is required that a subphony or other discovery process be served on provider directly. Next is searchability and e-discovery tools. In cloud environment, a client may not be able to apply or use a e-discovery tool that is uses in its own environment. Moreover, a client may not have the ability or administrator right to search or access all the data hosted in the cloud. For example, where a client could access multiple employees' email account on their own server at once. It may not have this ability with email accounts hosted in the cloud. As such, client client need to account for a potential additional time and expense this limit access will cause. To the extent the customer is able to negotiate or supplement the cloud service agreement, this issue could be addressed ahead of time. Preservation, depending on the cloud service and deployment model that a client is using, preservation in the cloud can be similar to preservation in other IT infrastructure, or it can be significantly more complex. In US, a party of general obligation has undertaken reasonable steps to prevent the destruction or modification of data in its possession, custody, or control that it knows or reasonably should know is relevant either to pending or reasonably anticipated litigation or government investigation. Next is data retention law and record keeping obligation. In addition to the data preservation obligation resulting from US law regarding e-discovery, company needs to be aware that the data retention law requires covering entities to retain data for a certain period of time. What we need to be considered inside the data retention, cost and storage. Preservation can require that the large volume of data to be retained for extended period. Customers should consider these questions and determine the risk tolerated before moving to the cloud. What are the ramifications of retaining data under service level agreement? What happens if the preservation requires outlast the term of the SLA? If the client preserve the data in place, who pays for the extended storage and what cost? What does the client has does the client have the storage capacity under the SLA? Can the client effectively download the data in an forensically sound manner so it can be preserved offline or nearline? Next is, what is the scope of reservation? A requesting party is entitled only to the data hosted in the cloud that contain or reasonably calculate to lead to relevant probative information for the legal issues at hand. The party is not entitled to all the data in cloud or in application. However, if the client does not have the ability to preserve only the relevant information or data in a granular way, it may require to over preserve in order to secure reasonable preservation depending on the investigation. The next is dynamic and shared storage. The burden of preserving data in cloud may be relatively modest if the client has space to hold it in place. If the data is relatively static and if the people with access are limited and known to preserve the data. However, in a cloud environment that the programmatically modified or purged data, or one where the data is shared with people unaware of the need to preservation can be more difficult. After a client determined what such data is relevant and need to be preserved, the client may need to work with the provider to determine a reasonable way to preserve the data. So this is what we are having till now. So in the next session we will be discussing about the other parts of electronic discovery. Thank you.